All right. Hi, everybody, and happy Sunshine Week. I'm Claire Regan, immediate past president of the Society of Professional Journalists and co-chair of SPJ's Freedom of Information Committee. I also teach journalism and advise the student newspaper at Wagner College here in New York City. This webinar is part of SPJ's special programming for Sunshine Week, when journalists across the country shine a light on the importance of access to public records, an open government, and transparency. Fun fact, Sunshine Week coincides with the March 16th birthday of James Madison, the fourth president of the United States, the father of the US Constitution, and a key advocate of the Bill of Rights. This webinar on Freedom of Information facts and guidelines is designed specifically for college students. To that end, I have the pleasure of introducing today's special guest, Mike Hiestand, Senior Legal Counsel for the Student Press Law Center, or SPLC. Mike has been involved with SPLC since 1989. He was an SPLC intern, its first legal fellow, and served as a full-time staff attorney from 1991 to 2003. Over the years, he has assisted more than 18,000 student journalists and advisors. As the SPLC's Senior Legal Counsel, he currently works from the West Coast on the SPLC hotline and related projects. In 2013, he traveled across the country with free speech icon Mary Beth Tinker, logging about 25,000 miles while teaching and speaking out on behalf of student press rights and free expression. Mike grew up in Alaska and graduated from Marquette University's College of Journalism and Cornell Law School. Before I hand it over to Mike, I'd like everyone here on the webinar to know that questions are welcome anytime during the hour. Just post them in the chat and I'll get them to our speaker. Mike, over to you.
All right. Well, thank you, Claire. Thanks for having me today. And honestly, talking about one of my all-time favorite topics, whether I'm talking with students or student journalists or others. I'm going to go ahead and share my screen here. Get started. Okay, hopefully you guys can see that. So yeah, we're going to talk about freedom of information law today during Sunshine Week. One thing I want to do before I kind of jump into the topic today is to just give a quick sort of infomercial about the Student Press Law Center and what we do for those of you that might not be familiar with us. If you are a student journalist, like I said, I mean, I'm glad you're here because sometimes you don't often need our services, but sometimes when you do, you need them pretty quickly. So Student Press Law Center, this is our 50th year of actually being in business. We were founded in 1974. We're based back in Washington, D.C., and our whole reason for doing what we do is to provide free legal help in information to student journalists at both the college level and the high school level. We work with advisors, we work with attorneys that are working with student media, but we handle pretty much, we answer questions on pretty much every media law topic that's out there. My specific job at the center is to operate our legal hotline. It's a free service where you can call or send us an email, and we can talk about, again, pretty much every media law question that comes up. We're going to talk today about freedom of information law, open records, open meetings, that sort of thing. But we hear questions on libel and on copyright. Unfortunately, censorship was the reason that we were founded back in 1974, and censorship is still the #1 reason that students, both at the high school and the college level, continue to contact us. So please do bookmark our website and just know that we're available if you need us. But we're here today, this week in particular, to talk about sunshine laws, freedom of information laws, lots of different names for them. But let's just, I guess, begin by kind of talking about what they are. What's the purpose behind freedom of information laws? The idea is that here in America, we've set up our system so that we are supposed to, citizens are supposed to be the owners of the government. We're the ones that the government is operated on our behalf behalf by government officials. And freedom of information laws are simply one tool that we've given ourselves, the owners of the government, to kind of keep tabs on what it is government officials are actually up to on our behalf. So it's one of those it provides an ability, I guess, to get behind the doors and into the filing cabinets of those that are actually doing the work on our behalf. When we talk about FOI laws, it's important to kind of understand that generally only public agencies are going to be covered by FOI laws. Public agencies are typically, recognized because they're supported by public funds. They are the ones that are responsible. The government officials are responsible for creating a governmental policy, passing laws. They're very often, the agencies are formed by the government itself, sometimes by statute or by regulation. And they perform a traditionally, public governmental function. For those of you on the call that may be calling from a private school, just understand that while your private school, while school officials there are probably not subject to freedom of information laws, a private school doesn't operate in a vacuum, and so we're going to be talking today about how you use these laws to get access to records by government agencies that may interact with your private school. The cafeterias on your campus, the elevators on your campus. I mean, those are all inspected, for example, by public bodies that are required to come in and do that inspection. And while you can't then go to your school and say, I'd like to see a copy of the latest elevator inspection report, you can go to the governmental agency that would be responsible for conducting that inspection and ask to see the report that they created about your private school. So, there may be sources, public sources of information about your private institutions that may be helpful. Today we're going to kind of get into it's a fairly basic overview of how these laws work. It can get a bit complicated, but hopefully we're going to leave you with enough information today to help you understand the basics of how they work and how you can actually use them, because it's really that's not that hard to do. So there are three different types of FOI laws we're going to talk about. The first is open records laws. Open records laws exist on both the state level and the federal level. Same with open meetings laws. There's both, every state in the country has its own version of the state open meetings laws, and the federal government has its version called the Government and Sunshine Act. And then I just call these things, the last category we're going to talk about, I call them little pocket FOI laws. They exist kind of apart from the big open records or open meetings statutes. They typically are, disclosure statutes or disclosure requirements that are built into much bigger bodies of law. For example, we're going to talk a little bit later about the Federal Clery Act, which requires all schools, both public and private, to provide information about campus crime. But it was part of this huge, this massive, Higher Education Act that was passed back in the 90s. And it was just a little tiny piece of that big law that basically said, if you're going to participate in federal funding programs, one of the conditions is you have to provide, basic information about campus crime. Unless you knew that it was in that big Higher Education Act amendment, you might not know where to find it. So we're going to talk about, Clery Act and a couple other things a couple other laws that might be helpful in your reporting. So let's start. We're going to start with open records laws. And like I said, every state in the country has its own open records law, and the federal government has its own version. The good news is they all kind of work the same way. I mean, the basic idea behind an open records law is that, the presumption is, and that's really important to keep in mind, the presumption under each of these laws is that every record, every document created by a public agency is presumed to be open and available for inspection, unless the only time they don't have to provide those documents is if the government, if the record keeper can point to a specific exemption in their laws that allows them to keep the records sealed. So again, the presumption is the records are open. You don't have to point to a particular piece of the law that says, that particular record is open. The burden is on them to point to a particular provision in the law that says we can exempt that information, we can withhold that information. So it's kind of an important principle in all these. Basically, state open laws are used to obtain the access to records of state, county, or local government bodies. So we're talking here about, city police, state troopers on a public college campus. That's also going to include your campus police. They would be considered governmental agencies subject to FOI disclosures. A public school district, public community colleges and universities, DMV, any sort of public, government, county, local, state agency is going to be subject to an open records law. If you don't do anything else during our presentation today, well, I want you to do two things. I want you to make sure you take down, our website at SPLC, just in case you have, questions that come up later on. But the other website that I want you to take down, the other resource, is this one created by the Reporters Committee for Freedom of the Press. It's called their Open Government Guide. And I tell you, I mean, their guide completely changed my life when it came out, many years ago now. But it's just such a wonderful resource for journalists, really for anybody that's working in FOI law, but for journalists and specifically, I mean, it was created for you. It was created basically Reporters Committee commissions FOI attorneys, people that specialize in this area of law, in each of the 50 states to put together this guide, again, specifically made with reporters in mind, to try and answer questions pretty quickly, give you yes and no answers. They try and, get away from, some of the really highly legalese sort of arguments and provide a very useful guide. For example, here, I'm actually, the SPLC is based in Washington, D.C. I'm fortunate to live in the other Washington State. And here in Washington State, our Open Government Guide, if I want to know our 911 tapes, for example, available here in Washington State. So I go to the Open Government Guide, and there is a specific section for each of the states on our 911 tapes available in our state. And here in Washington, yes, in fact, they are available. And there's a specific statutory provision that says that. So again, please take this down. It talks about yes and no. Is this record available? Is this record not available? It talks about specifics of request and documents in your state and penalty provisions and time, provisions and all that kind of stuff. So it's just a wonderful, wonderful resource.
Hey, Mike, we've put that link into the chat as
fantastic,
well, and the SPLC link as well, so everybody can look in there.
Excellent, thank you so much. So that's state laws. Like I said, the federal government has its own Freedom of Information law, the Freedom of Information Act, it's called, and makes that law is used to obtain access to records held by federal agencies. So FBI, EPA, Department of Defense, that sort of thing. It's important to remember now, this is, with respect to the federal law, there are certain things it doesn't cover. So Congress obviously was the one that was charged with enacting the Federal Freedom of Information Act. And one of the first things they did when they passed it was exempt themselves. So you actually cannot use the federal FOIA law to get records created by Congress. It also doesn't cover records created by the court system. There are other laws and procedures for obtaining those sorts of records, but the federal FOIA is not one of them. As we talked about earlier, it doesn't cover private corporations. It also typically doesn't cover federally funded state agencies. You'd probably want to use your state laws to get that. All FOI laws have some limitations. So the big thing to keep in mind with open records laws is that the laws only require the government agencies to provide access to existing records. Okay, so you might want a record that tallies up all of the number of a certain thing that happened at your campus. But if your school hasn't actually compiled a document that puts those numbers together, they're not required to create those in response to your request. They're simply required to provide access to records they've already put together. So they don't have to conduct any particular research for you. They don't have to add any sort of explanation to it. They just they can just give you the documents and say go for it, do what you want with it. No analysis or anything like that on their part is required. When we are talking about how do you actually use these laws, as I said, I mean, it really is pretty simple. The law really only gets complicated after lawsuits are filed and lawyers get and judges and everything get involved. For journalists, I mean, it's actually fairly simple. In order to request records, what I always suggest, and it's kind of a practical suggestion, is that, if you are able, I mean, if you're making a request, for example, to a school administrator that's on your campus that you have, fairly ready access to, set up an appointment, set up an interview time with them where you can go in and just explain, who you are and let them know, what you're doing. One of the things that I think is very helpful to do is let them know, hey, I'm not looking to, make, extra work for you here. So if there is a way of requesting documents, in a particular way that is less burdensome to you, let's do it that way. I'm happy to help you. Just find out maybe that, can they tell you what sort of records might be responsive to the sorts of questions that you have. But just kind of having that, that human sort of contact, I think can go a long way towards kind of greasing the skids and hopefully getting your hands on the information that you need. In some cases, if the government official is far off, or if you just know that they are not going to provide the information to you, or if you already asked and they've turned you down for that information, that's the point at which you do want to go ahead and submit a written request. When you submit a written request, it is a legal act. I mean, it is not something that the government agency, the employees for that are able to ignore. You have begun a legal action that they are required to, that they're required to respond to. When you submit your request, you don't have to, as the requester, you don't have to provide, a specific document number or a specific document title or anything like that. I mean, oftentimes that's information that's only held by the government record keeper themselves. You wouldn't have access to that. All the laws require that you do is that you reasonably describe the record that you're looking for, and provide enough information to the person receiving your request that they can, should reasonably be able to understand what it is you're looking for. Again, that's where maybe having that in-person contact where you can get into a little bit more of the specifics can be very helpful. The other thing you need to do is you need to send it to generally the person that's responsible for keeping the record. Now, the bigger the agency, the bigger the department that maybe you're seeking this information from, the more likely it is they might have created or appointed a specific Freedom of Information Act person or a public information officer that they've designated as, kind of the person they want to receive those documents. You don't have to go through them. I mean, you can send it to the person that you think actually is physically, responsible for creating that record. But usually it probably makes sense. They're used to receiving records in a particular way, and they often may have a form or something that they'd like you to fill out. It probably makes sense to play the game by the rules they've set up, at least initially. If they don't have a particular form or anything, we've actually tried to make it as simple as possible for you to actually, get your hands dirty and start doing this sort of work. It's one of my favorite resources on our website. We created it in the mid 90s. It's been used hundreds of thousands of times. Basically, it's just an automated FOI letter generator. And basically, you need, again, two different things in order to fill this thing out. You need to be able to reasonably describe the record that you're looking for, and you want to have the contact information for either the public information officer, that takes these FOI requests, or for the person that you think is, physically responsible for creating the record. You'll just want to get their name and their address, and you go and you fill out the form. And once you type in, that they are in Georgia, for example, it does all the other stuff. It goes out once you've hit the submit button. It pulls in the citation for the Georgia Open Records Act. It pulls in, any time frames that law might specify in terms of when they have to get back to you. It talks about penalty provisions that might exist in the law. So it does all that sort of work. You simply need to print it out and send it to the person that's that's the recipient for these things. What happens after that? So like I said, once they get, it's a legal act. So once they get it, that letter, they have two options. They either have to provide the record, the information that you're seeking, the record that you're seeking, in a timely manner. And most states do have time provisions that say, that once the government official gets your request, they have 3 business days to respond, or 5 working days, or 10 days, or something like that is spelled out. I think Maryland, it's common. I mean, 3 business days, 5 business days, 10 business days. Those are really, really common. I think Maryland right now has kind of the outlier. They allow government agencies to respond within 30 days. And unfortunately, there are still a handful of states out there that don't have a time frame. They just say that agency officials have to respond within a reasonable period of time. That just creates all sorts of issues, because obviously, many times, the government agent officials belief of what constitute a reasonable period of response is going to be different than me as a journalist wanting to get this information for a timely story. So so sometimes you have to, a little bit of pushback is required in those sorts of things. So they either have to provide the records to you in a timely fashion, or they have to provide you with a letter that says, hey, we're not going to provide this because of this exemption. The burden is on them to find the exemption in the law that they think allows them to withhold the record that you're seeking. If you think that your request has been improperly denied, there are a few things you can do. The first thing I would do is get on the phone, send an email to the record keeper. Again, hopefully maybe you've had some sort of contact already, and just say, do you remind them of the law, ask them perhaps, do you have any questions about what it is that I'm looking for? Because I really do think, this information ought to be available. Can I provide any sort of clarification for you? Try and work it out in a person-to-person sort of way. If that doesn't work, in about half of the states now, they do have an administrative appeals process that's available. A number of states have created kind of open records or freedom of information ombudsman's office, or public, records offices, where basically the idea is these agencies are typically funded and created by the state, but they're set up in a way that they're supposed to be neutral. They're supposed to be kind of mediators that if you get a denial back, you think it's improper, you can send it to them for basically an opinion. They will look at what you've requested and what the record keeper has said, and they'll say, they're right or you're right, and they'll issue an opinion. Now, those opinions, they don't have the same sort of weight as a court opinion, but they do carry a lot of weight. I mean, they are very persuasive. These offices, their whole reason for being in business is to interpret, their state open records laws and open meetings laws, and so they're kind of seen as experts, and judges will weigh, will take their opinion into account pretty heavily. So that's available. The nice thing about those things, it's free. You don't have to, engage an attorney. You don't have to pay an attorney. You don't have to pay court costs, all that kind of stuff. So really, really awesome where those sorts of options exist. If you do not have an administrative appeal process, or if you do, you don't want to go through it, or you get back an appeal, an opinion that you still don't agree with, you can always go to court. That's always the option in these cases, is actually to take them to court. As I mentioned earlier, there are typically fines, there are penalties to these laws. Most have either fines, most also have attorney's fees, which sometimes, if you have to take the record keeper to court, and if you win, the attorney fee provisions say that they would have to pay your attorney's fees. So there are there's some teeth to these laws that hopefully will persuade them to do what they need to do. So let's talk about some of the common exemptions, and that's really, again, that's where these laws differ from state to state. The basic idea, all records are presumed to be open, is the same in most of the states. It's the exemption really that is where the laws differ. Now, when we're talking about exemptions, I mean, the good thing is that a lot of the exemptions are going to be the same from state to state, and a lot of them, probably most of them, they reflect common sense. They make sense. When we see these exemptions, we understand probably, why they are on the books to begin with. For example, pretty much, well, not pretty much, every state in the country has an exemption in it that allows law enforcement agencies to withhold their reports, their documents, if they can claim that the release of those records would somehow jeopardize an ongoing criminal investigation. We all get it. We understand that, why it is we don't want to release, police wouldn't want to release some records at a particular time, if they're hot and heavy into an investigation, and releasing that information might, damage that investigation. We get it. We understand that. The problem is, it is without question, I think, all FOI lawyers would agree, it's the most abused exemption that's out there. I think there are certain police, law enforcement agencies that simply have, that letter, we can't release this record because it's part of an ongoing criminal investigation. It's just on their speed dial, on their automatic response. And so it's really important to be ready to push back against that. I mean, most of those exemptions do require that if they're going to invoke it, it has to be for an ongoing criminal investigation. I mean, once that investigation is concluded, typically for the police, that's going to mean, once they've made that referral to the DA or the prosecuting attorney, very often their work is over and that investigation on their part is done. And so at the end of that, they are supposed to provide that information. So just be willing to push back. Same thing, information that would jeopardize national security, very common exemption. We all get it, but it's also much abused. Police don't have to reveal their techniques. Personnel records are probably the exemption that varies the most from state to state. Some states are very open when it comes to personnel records. You can see salary information. Sometimes you can see like application materials that come in, and disciplinary proceedings or investigations against public employees. Those are available. Other states, and I'm thinking like Virginia right now, because I just was working with some students there. Virginia is very closed when it comes to pretty much releasing any information about state or local employees. They're much more kind of closed-fisted and that sort of thing. So that's where you would want to go to the Open Government Guide by the Reporters Committee, and they have whole sections in there on what sort of personnel records might be available in my state. Education records, obviously for student media, we deal with that a lot, but education records kept by a school are typically exempted, and that brings up this whole thing, which, if you are working in student media, this is just, or if you're an education law reporter or an education reporter, you're going to be dealing with this on a fairly constant basis. But there's a federal law out there called the Family Educational Rights and Privacy Act, or FERPA. And probably you guys have all heard about that already, but what a lot of folks don't know is that FERPA has kind of two sides to it. The one side is actually, it requires that schools actually provide information. If you are interested, for example, in finding out what your third grade teacher thought about you, you can actually send a FERPA request to the school district. If it's a public, you can send it to the school district you went to, and ask for a copy of my education records, my education file, and they will send to you, all your test scores and report card stuff, and any sort of comments perhaps that teachers might have talked about. She's a joy to have in class, that sort of thing. You can see all that. It's kind of interesting, but it's also kind of important when you are, for example, working with students that would like their stories told. Oftentimes, if you just go to the school, they will say they're not going to be able to release that information. But if you go to the student about whom the story is, if they're motivated to tell their story, and I'm thinking here about things like Me Too sort of investigations, Title IX investigations, and things like that, you can go to the student and say, can you make a FERPA request for all of the information about this case, and they can share that with you. So the one side of FERPA does require that schools provide your own education records to a student. The side that most student journalists come in contact with or are confronted with is the part that penalizes schools, basically says that schools are not permitted to release a student's education records without the student's consent. If the student's a minor, it would have to be parental consent. Now, the problem with that is that schools have really, I mean, that's the term it uses, education records, and schools have really uh, um, at times really abused sort of that the fluidity of that definition, and it pretty much called, any record that they hold, that might have anything about any student, they call it an education record. And the idea behind education records is, when FERPA was passed it was actually passed in 1974, so 50 years ago, just like SPLC. But it was passed for good reasons. I mean, in 1973, if you were an employer and you wanted to, you were thinking of hiring Johnny to work at your restaurant, you could go down to Johnny's high school and say, I'd like to see a copy of Johnny's, latest report card because I'm thinking of hiring him. And the school could, and there was some testimony that some schools actually did, give you a copy of Johnny's transcript, give you a copy of his report card. So, there was a lot of abuse at the time. And so FERPA came in and said, we do recognize there's some privacy interest in student education records. But the whole reason really was education records, student grades and transcripts and again, comments by teachers and things like that. But over the years, schools have really expanded sometimes, what they claim an education record actually is. For a long time, they were actually claiming that campus police records were education records. So you could go down to the campus police and say, I'd like to see a copy of the police log, what sort of things happened over the weekend. They said, love to help you, but that's all covered by FERPA. Luckily, that was all sorted out and taken care of, but just kind of an example of kind of the barrier sometimes that schools have created and using FERPA to limit access. FERPA really only applies to records. It doesn't apply to comments made by school officials or anything like that. It's fairly specific. FERPA, one thing that we've seen occasionally, not so much at the college level, more probably at the high school level, but occasionally we have school officials saying that, going after a student newspaper for publishing, information about students, claiming that, that the publication of that information violates FERPA. Important to remember, FERPA only applies to the release of information by school officials. Student journalists are not school officials. You're not subject to FERPA. So, publishing news about students in the student newspaper, you're free to do so. There's no FERPA problem there. So just be prepared to push back. The other thing is that FERPA only restricts the release of records that identify specific students. So either by name or by description. So, most statistical information, if it's just raw numbers, most of that information is totally can be released, and there's no FERPA problem in releasing that sort of stuff. All right. All right, so that's kind of how open records laws work. So now let's talk about, what can you actually get with these open records laws? So if you're wondering, for example, how much does my school spend on anything? How much is spent on, new football uniforms or library purchases? What are the salaries of, individual employees at the school, administrators at the school? Basically, where's my school's money come from, and where does my school's money go? That's all going to be in your school's annual budget. Now, when I give these lectures in person, sometimes I always ask for a show of hands. How many of you out there are actually requesting or looking at your school's annual budget on a regular basis? And I am just stunned by how few hands actually go up in the air. If you are a journalist, you need to be getting a copy of your school's budget. It's just a treasure trove of information. Shows, kind of, where school priorities are and where they're not. And there's just so much potential story stuff in a school budget. And it is meat and potatoes. There is going to be, with the exception perhaps of, part of the budget that might, talk about, how the campus police are spending money on, surveillance equipment, or, if there are certain security sort of issues that come into play, they might be able to withhold that sort of stuff. But for the most part, a school's budget is meat and potatoes, open records, and is available. You should get that at your budget office. office, the school central administration office. Many schools are posting their budget information, their budgets online. So yeah, definitely go out there and grab that stuff. If you want to know, about, transportation pool vehicles at your college, are they safe? Every school in the country is required to actually go out and do inspections on, school buses, transportation vehicles. And you can, do some stories about just kind of the condition of your fleet and stuff like that. Are my
Mike,
school, yeah,
can I ask a quick question 2 slides back about budget? You're
yes.
right. It is a treasure trove of story ideas in the school budget. So if a request is made and, in good faith with the right procedure, what obligation does the school have to respond in how fast?
So again, that's going to depend
Delays, right?
on the specific state. So, if you're in one state, they might have 3 business days to respond. In another state, they may have, a longer period of time. But yeah, no, they're supposed to provide that in a timely way. And like I said, because I mean, there's no legal, reason for withholding this stuff. A lot of schools just automatically post them online. So
Okay, so
yeah,
that's
it should be easy.
the required time to respond is according to the state that you're located in. Is that correct?
Yes.
Thank you.
So I think here in Washington State, I think we have like 5 business days, and in other states you have 10 working
That's good.
days, things like that.
Good.
Yeah. Oh, and we're back to school. Boy, if you want another sort of report that's gonna make your eyes water. Oh my God, probably make you never want to eat in your school cafeteria again. Yeah, get a copy of the regular health inspection report that comes through. It's it can be pretty eye watering. There's other things, lots of other sort of reports to explore. Accreditation reports are actually pretty. So all schools out there are required to, they to seek, if they want to seek accreditation, and pretty much all schools, all good schools at least do. They'll have people come on campus and basically look at the facilities and look what they're doing. And at the end of that time, they basically issue the school a report card that says, you're doing fine in this area, but you need to do better in this area. Those accreditation reports should be available to you. They're chock full of interesting stuff. Academic performance reports, how many students actually graduate from the school as opposed to how many enrolled. Building contracts, employee disciplinary investigations, as I talked about before. Those can vary significantly from state to state, but we've seen a lot of interest in those sorts of things, particularly as student media are getting into Me Too reporting, finding out how schools are addressing Title IX hearings and things like that. States take different sort of approaches. California, for example, is one state I've worked with a fair share, and in California, what the law says is that if there is an investigation of a teacher, for example, that the final report from that investigation is available if the investigation found there was some sort of wrongdoing. If the investigation found there was no wrongdoing, then it all kind of gets buried. Nobody ever hears anything again. But if there was a finding of guilt or wrongdoing, the final report on that should be available to you. Building inspection reports, elevator reports, things like that, fire safety, credit card statements. Oh, those are fun. Get the credit card statements from some of the top level administrators at your school. And then the last one here is also an interesting one. And I don't know if Claire, you've ever done this, but asking for an FOI, to find out who's asking for what sort of FOI requests are coming in from others. I mean, sometimes, that will clue you into, if a lot of people are asking for certain information, maybe you ought to be asking for it as well. So all those sorts of things should be good.
Summary question, your bulleted list here. So students are entitled to this information in your list.
That's correct. At a public school, yes, that would be correct.
Public school. Okay, private schools where it varies, and you might have to do a FOIA for a private school. Is that correct? Is that the difference?
So at a private school, a lot of these records are not going to be available.
Right.
There are, so like we talked about, I mean, you would be able to get like the building inspection, the elevator inspection from the state agency that comes in and does that. You'd be able to get that from the state agency, but not from the campus.
Right. Okay, that's good to know.
Yeah. All right, so that's kind of open record. So hopefully you've kind of whetted your appetite. Now let's dive into open meetings laws, and we'll do this fairly quickly because the idea behind open meetings laws is pretty much the same as an open records law. And again, every state in the country has its own version, but they all work pretty much the same way. The idea is that any public meeting, any meeting held by a public body is presumed to be open. Again, the presumption is that you're allowed to attend unless the government officials can point to a specific exemption in their open meetings laws that lets them close the door to the public. So let's talk about how do you actually go to these? It's even easier than making an open records request. You don't have to fill out any sort of paperwork or send a letter or anything like that. You just show up. I mean, the general thing you do is if a public body is having a meeting, they put out a notice about their meeting. That's part of what the open meetings laws requires. They actually require that the agency let people know that they are going to be meeting, and this is generally what we're going to be talking about. Once you've seen that, you can just show up. We generally suggest, if you're going to a public a meeting of an agency or public body that regularly, gets members of the public, like a school district or maybe a board of regents meeting at your school. They're used to having press there. They're used to having members of the public there. They probably understand a bit more about what the requirements are under the open meetings law, and they're not, they're going to let you stay there. As you get further away from those kind of top level sorts of agencies, so if you get into subcommittees or things like that, groups that maybe don't regularly have a lot of public participation, you may need to do a little education. So it's probably a good idea to, just take a look at your open meetings laws, look at the open government guide. They have sections on open meetings and open records. And so you can kind of get a general sense for what the exemptions, what the common exemptions are in our state. So you're prepared to explain that to them and push back. Yeah.
Question, does student government, does that qualify as a public?
Great. Such a good question. I'm glad you. It depends a little bit. So one of the first things we're doing when we're trying to find out, if we can send an records request or show up for a meeting, is we want to look at the definition in the state law of what constitutes a government agency or a public body. In many cases, student governments, if they do, most student governments, their main job is they take student activity fee funds. The school collects the student activity fee funds, at registration or whatever, and then they give those funds to student government to allocate. Basically, the student government in that situation is basically performing a governmental function. They're allocating public money, and under most state open records laws, that's one of the things. If you are allocating public money, or if you're conducting, if you're actually making policy, you're voting on things that actually it's more than just advisory, typically they are going to be covered. We actually have on our website, because it's such a big question, we actually have a special guide where we have gone through, because it's not in the open government guide by a reporters committee, but we've gone through and we've looked at all the different state laws and made our best determination about whether student governments would be covered or not. And it's just SPLC.org. Just go into our legal resources there and you can find that guide.
Thank you.
Yeah. So again, public meetings have similar, common exemptions. And again, usually they track common sense. Anytime they're going to discuss personnel matters, the hiring or firing of somebody, if they're going to discuss individual students, a lot of times, these sorts of things, the discussion, and this is important, the discussion of these matters can take place behind closed doors, or what they sometimes call executive session. They can go into executive session to discuss those things. But the important thing to keep in mind is they're only allowed to discuss behind closed doors. When they actually decide to vote, for example, on whether to hire or fire a particular individual, they have to do that in a public meeting, in the public setting. So if they're going to cite one of these exemptions to talk about things behind closed doors, there's a couple different things they have to do. One, before they go into closed session, they have to actually announce, we are about to go behind closed doors to talk about, a personnel matter. They have to cite to this specific exemption that allows them to go behind closed doors. And like I said, then they can go behind closed doors, do their thing, but they have to come back and actually vote in public. If they discuss things or do matters behind closed doors that they're not supposed to, the key remedy in those cases is pretty much anything they do behind closed doors is declared null and void, and they have to do it all over again, in a public meeting. So they can't just nilly-willy go into closed door session. Again, they have to point to a specific exemption, and you can challenge them on that if you
If
know your thing.
they have to disclose the reason for the executive session, and they can do it at that moment that they're going into executive session, or is there some kind of requirement for advance notice, or?
If they know for sure that we're going to talk about a personnel matter, if that's on their agenda, they probably are going to note that this is going to be done behind closed doors or something. But if something comes up and they decide that this needs to be done behind closed door, they can do it at that time.
Okay.
But yeah, usually they know they have a fairly general good sense of what they're going to talk about, and so that should be in the agenda in the notice provision. All right. So those, so that again, that's there are penalty provisions and attorneys' fees and things like that, just like with open meeting or open records laws. So there is some bite to those laws. The last thing I wanted to talk about before we kind of open it up to any questions that might exist out there are like I said, we have these pocket FOI laws out there. That's kind of my term, so don't be Googling that probably. But again, these pocket FOI laws, they exist in places that you kind of need to know where to look for them in order to find them. One of the big ones, and certainly for any private school student journalist that might be on the call here, this is a big one. So the Federal Clery Act was part of the Higher Education Act amendments back in the mid and early 90s. And basically up until then, so again, going back to, public records only apply to public schools. And so at a public school, your campus police at the public school are going to be treated pretty much the same as the city police, as the state police, anything like that. You should be able to get access to the same sorts of law enforcement records from campus police as you could get from those more, those other public agencies. At a private school, unfortunately, because they're at a private school, very often it was very difficult to get access to records that were kept by campus police. Now there have been some successful court cases out there which has successfully argued that hey, the campus police on our campus, they carry guns, they have the authority to make arrests. When you call 911, they are the group, that's the body that responds. And there have been some successful arguments made that hey, they act like the city police or the local law enforcement agency, just like they do the same things that they do, and they ought to be treated the same way. And some courts have bought into that. We have some court cases out there where judges have said that the campus police at a private school, if they do all those sorts of things, carry guns, make arrests, that sort of thing, we're going to treat them the same as other law enforcement agencies. Hasn't been the case in all the different states, and in some places, the campus police, maybe they don't carry guns, or they're more of a security force. But what the Federal Clery Act does, it says that any school that receives federal funding, and that's pretty much 99% of the schools out there, both public and private. If your school participates in federal student aid programs, work study programs, guaranteed loans, they are covered by, they are participating in a federal program, and they are subject to Clery. So Clery basically requires both public and private schools, but it's most important for private schools. It requires them to create an annual campus security report. Basically, it's kind of a statistical report. It's of limited value. It basically says, how many, robberies were there on campus, how many assaults were there on campus, has specific categories of crimes that schools are required to track and provide numbers for. That report is required by October of every year for the past year. And it helps you identify trends. Is our robberies up or sexual assaults down? That sort of thing. So it's a value, but of limited value. Probably the most valuable part of what Clery requires is that every school has to provide a daily campus police log. again, at a public school, you should already be getting this as part of your state open records law. At a private school, this really does provide kind of a window to what's happening on your school that wasn't available before. Within 3 business days, the school has to make available in a public log that you're supposed to be able to walk in, during their normal business hours and ask to see. A number of schools are actually posting them online as well, but it requires them to provide the what, the where, and the when of crime that took place on campus. It doesn't require any sort of who. It doesn't require any sort of names or anything like that. But it requires that they provide, basic information, not a ton of information, but basic information about what happened, where it happened, and when it happened. So, so if you're not already taking a look at those, make sure you do. Clary also requires what we call timely alerts and also emergency alerts. Basically, if there is any sort of ongoing threat to the campus community, maybe there has been, a number of sexual assaults on campus, and nobody's been arrested for it, but they're continuing. If that's the case, your school should be issuing a timely alert. Oftentimes, you're seeing these things in the form of text messages and things like that. There's also the emergency alerts, which schools are required to have systems in place now, if there are things like active shooters or things like that in place, ways to get the message out to the community as fast as possible. We had a hard time when Clary was first enacted, getting the Department of Education, the U.S. Department of Education, to actually take it seriously. But that seems to have changed. The law now does have some bite, and I need to change my slide here because was it last week or the week before, Liberty University in Virginia was hit with a $13 million fine for having violated the Clary Act. So there are some pretty significant consequences now to not complying.
Mike,
Yeah.
who monitors compliance? What agency or what department? Like, how is the compliance monitored?
So the Department of Education, the U.S. Department of Education, is the agency that's responsible, and there is a process. I think we actually have it we can help you find the agency that actually takes complaints and things. The part of that agency that takes complaints.
They check on colleges specifically. Like, does the Department of Ed do that? It does.
They do a little bit. They mainly respond to complaints, and so one of the things we actually have on our website is we actually have a guide to doing like a Clary audit. So you can go in and do some checking to see if your school is actually complying with Clary in the way that they're supposed to. A lot of the schools that have done this audit have found that no, my school really isn't doing what they're supposed to do. But yeah, if you find that they're not, a report to the Department of Education, and then they are supposed to launch their own independent investigation. And yeah, like I said, they just did that with Liberty and a $13 million fine. So yeah. There's a law out there. So that's the Clary Act, but there's another law out there called the Federal Student Right to Know Act. And that also applies to both public and private schools that receive any sort of federal funding. That requires access to student graduation rates. So again, finding out, basically that was an attempt to kind of get rid of diploma mill schools, but it shows, how many students actually apply to our school and how many actually graduate. And it breaks it down by race and gender and all that sort of thing. So that can be kind of helpful. And that would be available for both your school and for, any other schools that you might want to report on. Access to basic athletic program information. For public schools, you're going to be able to get a lot of this stuff simply by making public records request of the athletic department. At a private school, however, the Student Right to Know Act is one of the few, sorts of means that you have of finding out, again, fairly basic information about, how much money is coming into our athletic program, and how is that money being allocated. But both public and private schools are required to put that out as part of the Student Right to Know Act. And then the accreditation reports that we talked about earlier, the Student Right to Know Act, at least at a private school, is going to give you access to that information that you otherwise wouldn't have. At a public school, you should be able to get that again under your Public Records Act. The other one here is the IRS Form 990. Basically, the IRS Form 990 is the tax return, the annual tax return that's required of all nonprofit organizations. Student Press Lawson, we're a nonprofit. We actually have to file our IRS Form 990, and it's again going to provide basic information about where our money comes from and where our money goes to. All private schools are going to be considered nonprofit organizations. Even at a public school, this could, having access to a Form 990 could be helpful, because a lot of public schools we're seeing, are moving, so a lot of their resource collection and allocation into private university foundations. University foundations are, very common, particularly like for athletic programs. They go to donors and they dump money into these private foundations. These private foundations were started specifically to avoid having to comply with open records laws, and that allows them to keep the donor information secret, how much money is coming in, all that sort of thing. But the Form 990 will provide you with at least some information about what those private foundations on campus are up to. The Form 990 is required to be provided simply by walking into the budget office and asking for it. I mean, they are supposed to have copies available and on hand to provide to you. You can also go, there's this group out there, organization called GuideStar, so guidestar.org. They have done a great job of going out and just basically collecting every Form 990 they can from every nonprofit out there. And they've for schools, for bigger nonprofits, they are going to have your 990 online. It's all free, and so you probably don't even have to talk to anybody. You actually just go to GuideStar and take a peek and see what might be available at your school. Just some final thoughts here before we open it up. Is you're going to run into certain problems over and over. Delays are just so common. It's unfortunate. There's just legendary stories out there, under the federal act, the Federal Freedom of Information Act, for example. It's a 10-day sort of turnaround. They're supposed to provide information to you, but there are reports of just years, people having submitted their request years ago, and just having all sorts of delays and things like that. About the only thing you can do is just be organized. Make sure that you keep track of when you're submitting requests and who you're submitting them to. Put little notes on your calendar about when you expect responses back. Be patient. Even if it says they have 10 business days to respond, you probably want to give them at least 12 or 13 business days. You want to be, a little bit patient there, but persistence. I mean, really making sure that, when that little reminder comes up in your calendar that they are supposed to have gotten back to you, send them a quick email, make a phone call. Did you get a copy of the request? Is there any questions about it? Anything I can help you with? Because, I really need to get this. It's for a story I'm working on now. And just holding them accountable. Once in a while, we get to a point where a student newspaper just so frustrated by this constant backlogging and kind of stonewalling, they'll do an editorial, or they'll do a news story about what's taking place on their campus in terms of non-compliance with open records laws. High fees are also another sort of thing that we're seeing. And this has become a problem probably within about like the last 10 years. I've seen it really kind of escalate a bit, where I think that there are some state agencies or agencies out there that have seen that open records laws are a potential money-making proposition, and they charge big bucks to comply with your request. In many cases, especially for student media, they also understand the deterrent effect. If you send the student newspaper a bill for $1,000 to search for the records and provide copies of those records, there's not very many fairly poor student media organizations out there. They're going to be able to come up with $1,000. And so being ready to push back against that, there are certain strategies. You can request fee waivers if you're doing stories that have some sort of public benefit in many states. and some states also have, they spell out, what sort of fees are appropriate, what fees aren't. So if you get something like that back, if you're facing big delays or facing high fees or any sort of pushback, that's when you would want to make sure that you have our contact information ready, because I'm happy to talk with you about, what you're doing and help you do it better.
Great to know you have students' backs. You do. The
Yes,
SPLC.
we got your back.
Yes, that's great. You're advocate.
So I'm
I'm
gonna come
looking
back here. That's cool.
and I'm just putting the call out for questions. This is your chance for the next couple of minutes for questions in the chat. Oh, thanks for the contact. That's great. I have a quick question. What is the most common FOIA request that you see at the SPLC where students might have trouble with it and that comes to your attention?
I'd say probably the number one source is campus police records.
Yeah.
It has been a constant battle, and when schools have to talk about campus crime, it's not great for marketing and PR and things like that. And so, very often they are doing what they can to kind of, keep that picture, that rosy picture of, their tranquil campus, keep it unvarnished. And so, it can be really challenging. And I think that's probably, without question, that's the number one reason they
And
contact
how
us.
does the SPLC step in if it comes to your attention that there's a delay or non-compliance? How do you help the students?
So, one thing, if it's delay, obviously we look at the law and see exactly, how much time they have, and we'll talk about kind of just some strategies for making sure we contact the record keeper and doing that sort of thing. If they truly are just delaying, delay is a form of denial. Courts have said that, at certain point, if they're just not responding, you can treat that as denial, and then you can go and take an administrative appeal if that's available, or a judicial appeal, something like that. Fees, that's I do encourage anybody that's getting back, really big bills, to give me a call, because one of the things we talk about is, maybe narrowing the time frame of your request so that you're not, asking for a year's worth of records, at least initially. Maybe you're asking for a month's worth just to see, are they going to be responsive? We'll look at the law just to see, are there specific fee provisions and are they in compliance? Maybe there's a fee waiver provision that's available as well we can look at. So yeah, fees are one of those things you probably do want to reach out so we can get into the nitty gritty.
I'm glad you bold-faced persistence, because I know as a college professor, I know students feel like they're bothering people or they're pestering, but persistence is the best way to get the information that you need, right?
It is the best way. And just to all those students that are, that are worried about bothering them, understand that school officials know that your time at a school is limited, that time is on their side. And so please don't think that you need to understand that the clock is ticking, and they will wait you out if you let them wait you out. That is a very common tactic.
Yeah, I guess the delay is hoping that the request will go away or the student will
Hope it will go away. Absolutely. Yep.
All right. I don't see any questions, Mike.
All right.
But I do want to thank you. Our hour is about up. And just really thank you for opening our eyes to our right to information, our meaning college campuses and college journalists. And it's really refreshing to know that they have the SPLC on their side and they can reach out at any time to you, right? You and
absolutely. Yeah. Thank you so much. And yeah, use it. Use the sunshine. Good stuff.
Right. Happy Sunshine Week, everybody. And thank you, Mike.
All right. Take care, y'all.
Yeah. Bye-bye.
Bye-bye.